Good morning, everybody. Thank you so much for joining us today. We are going to be giving a presentation called Know Your Rights about sexual assault. We have a lot of information for you all today. I'd like to start by introducing us and then talking a little bit about what topics we're going to be covering. As we mentioned, please feel free to anonymize yourself, picking whatever name you'd like, and you do not need to turn your video on. My name is Myka. I'm a senior staff attorney at Legal Aid Chicago. Also with me today are Nina Terebessy, Biz Reilly, and Marco Penaloza. From Resilience, we have Carolina Sánchez joining us. Carolina, would you like to introduce Alex?
Yes, of course. So in addition to myself, we also have Alex Martinez joining us. She is going to be a safe person available to people who might want to check in. Maybe something is triggering or they just want to kind of ask some questions or need emotional support. That is what Alex Martinez is here for. So you can feel free to message her directly to get connected. Thank you.
To give a little bit of context, Legal Aid Chicago and Resilience both offer free services to sexual assault survivors in Cook County, regardless of income. Resilience and Legal Aid Chicago work together to provide holistic services to survivors of sexual violence. Resilience offers crisis intervention, medical and legal advocacy, and trauma therapy services to survivors, whereas Legal Aid Chicago provides comprehensive legal services for personal safety, housing, employment, immigration, education, and financial legal issues, among other issues. Throughout this presentation, we will be using survivor and victim interchangeably. I also wanted to let you all know that we are not using one specific definition of sexual assault or sexual violence because most of the laws we talk about use different definitions of sexual assault. Generally speaking, though, sexual violence refers to unwanted or coercive sexual behavior. Also, sometimes on slides, we use SA to mean sexual assault and DV to mean domestic violence. Today, we're going to be talking about rights that sexual assault survivors have around protective orders, education, employment, immigration, medical options, criminal cases, crime victims compensation, civil lawsuits, family law, and housing. That's a lot of topics, so we're going to be very brief on each. If you have more in-depth questions about something, we're going to have our contact information at the end, and you are welcome to contact us after the presentation if you have more in-depth questions. We're going to start by talking about protective orders. If you have been sexually assaulted, you are entitled to a protective order that bars the perpetrator from contacting you or being near you, regardless of whether you have reported to the police or sought medical care. In protective order cases, the victim is called the petitioner and the perpetrator is called the respondent. Minors can obtain a protective order, but they do need an adult. It does not have to be their parent, but some adult to file on their behalf. Remedies that you can get in a protective order, and these are not comprehensive, these are the main ones. So if you have specific questions about what you can get in a protective order, that is a more in-depth question you can ask us later. First and foremost, no contact by the perpetrator or even through third parties, meaning the perpetrator can't use your friends to contact you or the perpetrator can't use his friends to contact you. You can get protection over your household members, the people you live with. You can ask that the perpetrator stay away from your home or other important addresses like your child's daycare, your school, your work address, your gym. You can get exclusive possession of the home if you share a home with the person who sexually assaulted you. That's only in an order of protection. And we're going to be talking in the next slide about the 3 different types of protective orders. You can get child-related remedies in an order of protection. You can get monetary reimbursement in an order of protection only. And you can get an order that the respondent has to transfer out of your school if the respondent goes to school with you. That's in an order of protection and CNCO case only. What do I mean by order of protection and CNCO or civil no contact order? So an order of protection is a domestic violence specific order. Domestic violence can sometimes include sexual violence. In order to get an order of protection, you need to have a dating or household relationship with the perpetrator. A civil no contact order is specific to sexual violence. It's for people who have experienced sexual assault, either contact or penetration. You can have a dating or household relationship with the perpetrator, but you don't have to. In a stalking no contact order, this covers stalking, which can include sexual harassment or violence as part of the stalking. For this order, you cannot have a dating or household relationship with the perpetrator. It's for people that you are acquaintances or strangers with. The initial protective order that you can receive is an emergency order, and it lasts for 21 days at a time. After the emergency order, you need to have a hearing in order to get the plenary order, which can last for up to 2 years. If a state's attorney is pursuing a criminal case where you are the victim, you may be able to pursue a protective order within the criminal case, but you have to request it. They don't do this automatically. To get a protective order, you can go to 555 West Harrison, the domestic violence courthouse in Chicago. You could go to any suburban courthouse, or you could go to any courthouse in the county where the abuse happened or where at least one party lives. Next, Nina is going to be talking about education.
So the one kind of primary law to be aware of when it comes to sexual harassment or a sexual assault that happened at school is Title IX. Title IX is a federal law. It's been around for a while. It's been around since 1972, and it prohibits education programs from discriminating on the basis of sex. The kind of underlying assumption of Title IX is that access to education is a fundamental civil right, and that discrimination or harassment can really serve as a barrier to that access. That language on the basis of sex is very broad. It includes a lot of different things, from discrimination in admissions to athletics to policies impacting students who are pregnant or parenting. But it also requires schools to respond when they have knowledge that sexual harassment or sexual violence is happening within their program. Title IX applies to students, it applies to teachers, it applies to anyone who's really attempting to participate in the education program. It only applies to schools that receive federal funding, but that's going to be all of your public K through 12 school districts, most colleges, most universities, and some private schools as well. Looking kind of at a minimum, education programs under Title IX have to have a Title IX coordinator. They have to have a non-discrimination policy. And then they have to have grievance procedures that outline how the program will respond if it receives a report of sex-based discrimination. The expectation is really that schools have grievance procedures for addressing all of those forms of sex-based discrimination that I mentioned. But when it comes to sexual harassment or sexual assault, those grievance procedures have to include kind of two important things that we wanted to highlight today. The first is supportive measures. So if a student reports that they've been sexually assaulted or sexually harassed within an education program, so either on school grounds or when participating in a school-sponsored activity, they're entitled to receive supportive measures. That might be a change in class schedule. That might be a safety plan or time with the school social worker. It could be a safety transfer to an entirely different school in the district. The idea is to put in place supports to preserve that access to education. And those supports are something that should be tailored to meet the individual needs of the student. So that's kind of the first one. The second one is that Title IX provides the right to an investigation. So a student who experienced a sexual assault or has experienced sexual harassment can receive those supportive measures without moving forward with a school-based investigation. But if they want the school to investigate, and importantly, if they want the school to potentially discipline the perpetrator, they have the right to file a formal complaint, which would then trigger an investigation. There are a lot of kind of procedural steps in the investigation that we just don't have time to go over today. But just kind of the main pieces that have to be part of that investigation, the main rights that you would have, is that you have the right to receive kind of a formal notice letter letting you know that the investigation is opened and letting you know what the district is investigating. You have a right to present witnesses and present any relevant evidence that you want the district to consider as part of the investigation. And then you have the right for the district to conduct that investigation within a reasonably prompt timeframe. Title IX is kind of an area of law that is very much in flux right now. So it currently utilizes a very specific definition of sexual harassment that is likely to change at some point this year. And that expectation that education programs are only investigating conduct that happened on campus is also something that is very likely to change. But I think the takeaway is that if a student has been sexually harassed or has been sexually assaulted by a classmate, by a teacher, by someone else, some other staff member in an education program, Legal Aid Chicago would be a really great resource to help that student understand what their options are and navigate the Title IX process. Or if it's not something that falls under Title IX, kind of assess what other avenues we might have to help make sure that that student feels safe at school.
Thank you, Nina.
Okay, now we're getting into options that survivors have in terms of their employment. So in the state of Illinois, we have a law that is called, for short, VESSA. It's the Victims Economic Security and Safety Act, which allows employees who have experienced gender-based violence, it could have been domestic violence, sexual violence, human trafficking, stalking. It allows them to be able to take anywhere from 4 to 12 weeks off of unpaid time off. This is protected time off from work, so that employer couldn't try to threaten the employee with cutting their hours, firing them, disclosing their status as a survivor of gender-based violence to anyone else within the workplace, things like that. This does also include family and household members of survivors. And so in a situation where a child was the victim or survivor of sexual violence, this is a law that their parents or legal caretaker or legal guardian would be able to use in order to take time off and potentially go and file a police report, go to the domestic violence courthouse and petition for a protective order on behalf of that survivor. It could be in order to receive counseling or trauma therapy services, whether that's for the child or the parents or both, as well as receive any other legal assistance or additional services that they may be in need of. This additionally also provides reasonable accommodations. So we already talked about accommodations in terms of educational settings. This law also allows for certain accommodations to be provided to survivors or their significant others. So it could be, for example, again, taking that time off, potentially changing their work responsibilities, or just in general, allowing them that flexibility to be able to attend to their needs and their needs of the survivor, in addition to keeping their work, kind of going as well as possible. Myka, if you can go to the next one. If possible, employees must give 48-hour notice to the employer. We know that that's not always possible. We know that in a situation of sexual violence, for example, it could be that same day that survivor has to miss work to be able to go to the hospital or to go and file that report, right? And so those 48-hour notice is not always going to be practicable. So then what the law states is that the survivor just, has to notify their employer as soon as possible. That employer may require some kind of certification from that survivor to kind of prove that they have experienced this kind of violence and the reason why they need to take that time off. This could be a sworn statement by the employee themselves. It could be a copy of their police report. It could be a letter from an agency such as Resilience, a victim services organization, where we are stating, this individual did experience sexual violence. Unfortunately, they are working with us, receiving services from us, and will need time off. The employee can choose what certification they want to provide. The employer cannot force that employee to provide some sort of certification that they do not have in their possession. So they cannot force them to go and request, a medical record and turn that entire record in. If that is not something that the survivor feels comfortable doing or wants to do, one of these other forms of certification should be accepted by the employer. The employer cannot or may not require more than one document certifying the need for leave in a 1-year period. And the employer, as I mentioned, must keep this information confidential. So they cannot go around, disclosing to fellow coworkers the situation that this employee experienced, or even tell other individuals potentially in leadership if it's not on a need-to-know basis. VESSA leave can be taken consecutively, intermittently, or on a reduced work schedule basis. So it really does depend on what that survivor and their family or their loved ones need. More often than not, survivors are only taking it intermittently, right? So maybe they take tomorrow off so that they can go petition for that protective order, and then maybe 2 weeks later or 3 weeks later, right, when they have to go back to court, they'll take another day off. There are some survivors though who feel that they need to take more extended time off. Again, this is unpaid time off, but it's protected. And so some survivors will choose to go that route and take, a couple of weeks at a time off. It is important that people know that eligibility restarts after a year. And so if within that initial year from the first date of notice to the employer, after a year, whether or not you used up to those 12 weeks, the following year, it restarts. And then if that survivor feels that their rights have been violated in any way under VESSA, they do have a right to file a complaint against the employer. And that is something that Legal Aid Chicago is able to assist with. And so if that survivor is working with us as an advocate, we can refer them to Legal Aid Chicago for that support.
Marco is going to talk to us a bit about immigration now.
All right, yes, I want to talk to you about two important remedies in immigration context for victims. The first one is the U-Visa. U-Visa is a benefit for victims, direct victim or indirect victim of a qualified crime. In the list of crimes that allows to a victim to apply for a U-Visa, there is specifically the sexual assault as one of the crimes that allows you to apply for this benefit. The victim have to prove that she suffered substantial physical, mental harm as a result of the crime. The victim can prove that through the victim declaration, witnesses, consular support letter, or medical records, for instance. There is an important part of this process regarding the interaction with the law enforcement office. The victim has to report the crime, and also the victim has been cooperating with the investigation. As well, the victim have to provide enough information in the context of the investigation. If so, the victim is allowed to request the certification from the law enforcement office. Without this certification, the victim cannot apply for a U-Visa. That's why it's important. In addition, Legal Aid Chicago or your immigration attorney have to assess another circumstances regarding your immigration history or your criminal background to decide if it's a good idea to go for the U-Visa. In terms of, I want to add something about the U-Visa benefits. The U-Visa provides you first a work permit, social security number, and a legal status for 4 years. and the opportunity for apply for a green card after at the end of all this process. Regarding the timeline, the bad part is that you have to wait from the time that you apply for the U visa. You have to wait more or less 6 years to receive the final decision regarding your application. But the benefit is that in this period of time, you can apply for a work permit to work. Meanwhile, immigration decides about your application. Okay, let's talk about the VAWA. VAWA is a benefit for abused spouse or child of a United States citizen or a legal permanent resident, or an abusive parent of a U.S. citizen. As you know, the sexual abuse can be considered, the sexual assault, I'm sorry, can be considered as an abuse in this context. The victim have to prove the residence in the United States with the abuser in any period of time. Specifically regarding the marriage relation, the victim have to just prove through the utility bills, tax returns of pictures that they shared the same address in the specific moment, in the specific time in the relation. The victim have to prove good moral character. That's more related with any kind of criminal background or probably use or abuse or some substances. In this benefit in VAWA, the victim no need to get a certification for any law enforcement office. But anyway, they need to prove the evidence. As I said, in the U visa, they can prove the abuse through the witnesses or consular support letters, etc. Regarding the benefits, the U visa applicant can apply for work permit. They're going to have a kind of protected status. It's not like the visa status, is more like a DACA status, but anyway, it's a good resource for the victim. Of course, they will be able to get social security number. At the same time, it's not as bad as the U visa. The applicant have to wait more or less 3 years for the last decision in the case, and after that, they have to wait 1 year, around 1 year, to apply for a green card. That's it.
Thank you, Marco. We're going to have Carolina talk about medical options after you've been sexually assaulted.
Here we go. So in the state of Illinois, we have a law called SELF-PETITION for short, but it's the Sexual Assault Survivors Emergency Treatment Act, and it mandates that all licensed hospitals have to provide free healthcare services to all survivors of sexual violence who show up to their emergency departments, and that also includes medical forensic services. SELF-PETITION prioritizes survivors of sexual assault, and so whenever a survivor shows up to the hospital and they disclose that they have experienced sexual violence, they are prioritized. They're second only to life and death patients, so they get to jump the list of patients who may be waiting, and they should also be placed in a private, closed environment to ensure privacy as soon as possible after their arrival to the emergency departments. SELF-PETITION also mandates that an evidence collection kit, it's called the Illinois State Police Evidence Collection Kit. It's a very long name, so we just refer to it by as an ISPEC. But SELF-PETITION mandates that an evidence collection kit be offered to a survivor if they enter the emergency department within 7 days of the assault. This is a key word, being offered. It's not that it needs to be given or that it has to be done on a survivor. is that it has to be offered to that survivor. And so if they choose to go through with it, then they can. If they choose to decline, then that is entirely their option. It is important that you all know that anyone at any age can consent to evidence collection, but only people who are 13 or older are able to release it on their own for testing. For children 12 and under, either a parent or legal guardian is able to release it, but if there are any concerns or for some reason that parent or legal guardian is unable or unwilling to release the kit for testing, then DCFS or law enforcement can kind of jump in and release it on their behalf. It could be that there are concerns related to abuse, potentially that parent or legal guardian is the abuser or is protecting the abuser, or it could be completely unrelated. Regardless, there is a possibility to have those third parties be able to release the evidence collection kit. On average, it takes about 6 to 8 months for kits to be tested, which is not what you would imagine based on, Law and Order victim, those kinds of shows, right? Like, it's not like that in real life. It does take several months for those kits to be tested and for the results to come in. While in the emergency department, patients must be offered a head-to-toe medical exam and gynecological exam, if applicable, by a qualified medical provider, which now includes SANE nurses. So every hospital throughout the state of Illinois should have a SANE nurse or a qualified medical provider who has received specific training in working with survivors of sexual violence and performing evidence collection kits. If a SANE nurse or qualified medical provider is not available for whatever reason at the hospital that the survivor showed up to, that survivor can request a transfer to a different hospital that does have one. And just so you all know, Resilience does partner with 15 hospitals throughout the city of Chicago. I believe that we will be sharing a list of those hospitals. And so if a survivor shows up to any one of those 15 emergency departments, an advocate, if available, which usually that is the case, will show up and be there with that survivor in person, provide emotional support, provide information about the rights and options, assist them in any way possible. So that's important for you all to know. Not all hospitals partner with the Rape Crisis Center. So if you or someone you know is interested in accessing healthcare following a sexual violence, a case of sexual violence, I do recommend that you that people go to a hospital that has a partnership with a Rape Crisis Center. It is important that medical staff observe and document any signs of trauma, that they diagnose any ailments or injuries, and that they offer treatments for STIs, which are sexually transmitted infections, HIV, and potential pregnancy. So during that emergency department visit, the medical professionals will be conducting some testing and offering treatment for those prophylactic treatment, which means, trying to treat it before it actually develops, before that infection or that disease develops. All patients can return to the same emergency department within 180 days to receive pre-follow-up care. That used to be only 90 days. It just changed at the beginning of this year. They extended it to 180 days. And they also are able to access care elsewhere free of cost if they have been given a sexual assault emergency treatment program voucher. We just refer to it as a voucher, which basically allows for people who either have no insurance or who have private insurance to be able to access follow-up care without having to worry about, I can't afford the copay, I can't afford to pay the medication, I don't have insurance, so I don't even have a primary care physician to go to. This gives people access to healthcare for up to those 180 days. The voucher can cover exams, STI testing, lab work, medications, also mental health care, physical therapy, and termination of pregnancy, if that is something that a survivor is interested in accessing. No address or social security number is needed in order to generate a voucher. So even survivors who may be undocumented or, again, don't have insurance or anything like that, they do not have to worry about that. That hospital should be able to generate a voucher for them. There's also a new option that also just went into effect for survivors to opt out from billing their private insurance if they're not the primary policy holder. So we oftentimes get cases where it might be a college student who's still under their parents' insurance. They don't want to tell their parent that they experienced sexual violence. They don't want their parent to find out for whatever reason. And so now this is a way that they can receive the healthcare that they need without concern for their parent finding out through the explanation of benefits or any documentation that their insurance may mail them.
Hi, Carol. Sorry, I have a question.
Hi, Randy.
So for that new option for survivors to opt out, how can they go about it? Let's say if the hospital does accidentally end up like billing their primary healthcare insurance.
Yeah, so with CESITA, right, people who do have insurance, whether that's private insurance or through public aid, they first have to bill the insurance, right? And so whenever that's an option, they will use it because CESITA and crime victims compensation, they are the payer of last resort, right? So whenever possible, they'll try to get their money first and then deal with whatever may be left over that wasn't covered. So if a survivor is concerned about their parent finding out or, not wanting for the explanation of benefits to go out to the policyholder, this is something that should be communicated from the beginning at that emergency department visit to ensure that it gets classified correctly during that visit so that there's no concerns moving forward. If the insurance has already been billed, maybe this wasn't communicated, maybe the survivor didn't know, maybe the advocate forgot to mention it. Hopefully that's not the case. But if they do bill that survivor or the primary policyholder, then unfortunately at that point, there's not a whole lot that can be done if they already received that notification. So this is one of those situations where we have to be very proactive from the get-go to prevent the issue from happening.
Gotcha. So there's no form, for example, that the survivor needs to fill out if they don't want their primary insurance to be billed, right? It just has to be mentioned in the beginning so it could be classified correctly.
Yeah, then I see Sarah raising her hand. Sarah.
Hello, I just wanted to jump
Hi.
in and say that in the emergency room, if somebody opts out of having their insurance paid, the reality is it's going to go under self-pay. So that survivor should likely anticipate a bill. Hopefully on the back end of the hospital, their billing will catch it because it was coded as sexual assault and won't generate a bill. But based on my experience, what I think that'll look like is that survivor opting out in the ER, having it on the radar of that survivor and hopefully that advocate that is in the hospital and rape crisis center that a bill could potentially be coming. So then we can do that advocacy with the hospital, letting them know that the self-pay option is actually prohibited, reminding them of this amendment now that you can opt out and directly bill the sexual assault program. So I do think advocates are going to be really critical and watching what happens once they opt out.
Yeah. And Andy, if you have any other questions, because we are pretty limited in time.
Yeah, I'm sorry.
No, you can definitely feel free to reach out to myself, to Sarah, to whoever at Resilience, and we can definitely get more in depth with this information.
Sounds good. Thank you.
Of course. Myka, did you want to say something? I see you're unmuted.
Oh, I've been unmuted. I was just going to say if we can hold all questions because we have quite a few more slides to get through.
So much more to cover. Yes, thank you. And also, yes, feel free to add questions in the chat as well. And hopefully we'll have time at the end and we'll be able to answer them. But if not, we'll figure out a way to get you the answers that you need. So continuing with the medical options, survivors who may become pregnant as a result of their assault are able to access a termination procedure. That is something that an advocate can assist them with, looking into options for what clinics they can go to. Do they offer some sort of, if that survivor has insurance or has a voucher, do they accept that? Making sure that, as much as possible that survivor won't have to pay. There's other options for payment as well. So we can, if you have questions about that, we can get into that at another point. But it's just important that you know that is an option that is available. An advocate can also accompany them to follow up medical appointments. It is recommended that survivors who have experienced sexual violence be tested for STIs at 6 weeks, 3 months, and 6 months following an assault. as you all may know, it can sometimes take some time for symptoms to show up or for tests to actually come back positive if somebody did contract an STD or an STI. And so it's important that there's kind of testing that's being done sort of regularly to ensure that that survivor continues to be safe and healthy. Resilience, I mentioned, partners with 15 hospitals. We'll be sending that list to you. If drug-facilitated sexual assault is suspected, survivors are also able to submit a urine sample to have that be tested for toxicology by the Illinois State Police Lab. Some hospitals may also do their own testing internally, but we have to make sure that if that survivor wants it to be part of the evidence collection kit, that it actually gets sent with the evidence collection kit. And additionally, very exciting, kit tracking is now available in Illinois. And so survivors who do opt to do the evidence collection kit are given a K number and a PIN number, and they're able to input that information and get updates on their evidence collection kit where they're at in the process. As far as the evidence collection kit, there also is the option to do for forensic photos to be taken of injuries. That can be done by the hospital department. Separately, law enforcement could potentially send a lab tech to take their own photos, but the ones that are taken by the hospital are to be held in the highest of confidence. And so nobody really can access them until there is a criminal case that is currently being prosecuted, and a judge orders that those pictures be released as part of the criminal case. There is the option to file a police report, and then there's separate parts to the consent to the evidence collection kit. So a survivor can consent to having to self-report and have the police report and have the evidence collection kit be released for testing or held in storage. Additionally, they can have a third-party individual file that report on their behalf with their explicit consent. And then again, the survivor can choose to release the kit for testing or have it held in storage. Or a survivor who does not want to speak with law enforcement, they do not want to make a police report, maybe not yet, but they do want an evidence collection kit to be completed, they have the option to do that anonymously. And then they will have 10 years from that date to decide whether they want to make a police report and release the kit for testing or not. If a survivor is a minor when they experience sexual violence, they have up until their 28th birthday to release that kit, which is incredible because when I first started 8 years ago, survivors had 2 weeks to decide whether or not they wanted to release that kit. So to go from 2 weeks to 10 years, or potentially up until somebody's 28th birthday, that is a huge victory for survivors. Additionally, advocates can assist survivors, like I mentioned, in reporting and releasing their kits down the line if or when a survivor is ready for that. In terms of criminal options, and I'm going to do my best to fly through these, SEPA, the Sexual Assault Incident Procedure Act, makes it so that law enforcement cannot refuse to take a complete report of sexual violence that a survivor wants to make, whether the abuse happened in their jurisdiction or outside of their jurisdiction. Advocates can accompany that survivor to make a police report and helping them navigate the criminal legal system. Especially, we see issues where the abuse happened outside of CPD's jurisdiction, for example. CPD oftentimes is like, well, that's not in our jurisdiction, so we can't take a report because we can't investigate it. But in reality, they are able to make a police report and then they have to forward it to whichever law enforcement entity has jurisdiction over the case. Which is also a great victory. No law enforcement officer or entity should force a victim or survivor to go through with an interview. And that also includes children, elderly adults, or people with disabilities, which is very important that we mention. And then there's also something important to mention is that hospitals do have to notify law enforcement whenever they are treating a sexual assault survivor. However, they do not have to share any personally identifying information. They simply have to state, we have a survivor of sexual violence here, law enforcement will show up, and then it is up to that survivor to decide whether or not they want to speak to law enforcement and potentially file a report. In terms of the criminal investigation process, once a police report is filed, that oftentimes is with a beat officer, somebody who's in the blue uniform. They will take the initial report, then the case gets assigned to a detective who will, begin to gather evidence, speak to the survivor, speak to any witnesses. If there's any, for example, security footage or anything like that, that they believe would be corroborating evidence in the case, they go out and gather that, and they basically just conduct, or should be conducting, a thorough investigation. Once they feel that they have enough information, or that they have all of the evidence in the case, then they call they call the state's attorney's office, and they have a state's attorney come into their station and conduct what is called a felony review, which basically means they are looking from beginning to end, all of the evidence, all of the statements. They're looking to see, is there enough corroborating evidence to charge this as a felony? There is a high burden of proof, right? It has to be 95% or higher probability that this happened, right? And so it's a very high burden. Unfortunately, the vast majority of cases are not prosecuted, which, is a whole another rant that we can go down on at another point. But basically at that time, that's when the state's attorney's office is deciding whether or not to prosecute a case. So it is not that survivor decides, I want to file, I want to press charges, and I want this to be prosecuted, and I want this to be, for this individual to be convicted. It is not up to that survivor. It is up to law enforcement and the state's attorney's office to decide that based on the evidence at hand. This is information just about charging a case, right? Like what happens once a case is actually charged. For the sake of saving some time, we're gonna pass through. This will be posted on our YouTube pages. So if you're interested in kind of looking into that a little bit down the line, you're able to access it there. In terms of statute of limitations, this is another huge victory. The statute of limitations basically is non-existent anymore for cases of sexual violence for both child survivors and adults. It was removed for children as of August 11th of 2017, and as of January 1st, 2020 for adult survivors. And so any offense that was viable as of those dates may be prosecuted at any time if there's enough corroborating evidence. And I say may be prosecuted, and if there's enough corroborating evidence, because at the end of the day, that is what's needed, right, in order to charge a case. So if there's no physical evidence, if there's no witnesses, if there's no sort of other evidence that can be used to prove this case in criminal court, it unfortunately may not be prosecuted. However, survivors will still have the option of filing that report and having, there being a record that this happened to them. I'm also not going to get into this, but this is basically the difference between the criminal and civil legal systems. The main thing that I do want to mention is the burden of proof, right? For a civil case, that's by preponderance of the evidence, which just means about 51% sure that this happened. Whereas for criminal cases, it's beyond a reasonable doubt. So it has to be 95% or higher likelihood that this actually happened. We can move forward. I mentioned, unfortunately, the vast majority of cases of sexual violence do not result in the prosecution or conviction of that offender or of that perpetrator. So unfortunately, filing that police report is not a guarantee that someone will be prosecuted. However, for many survivors, having that report made can be the beginning of their healing journey and of feeling that there's some sort of accountability for the harm that they experienced. And as you can see here, yes. So out of every 1,000 sexual assaults, 975 perpetrators will walk free, which is such a heartbreaking statistic. And, it makes sense that so many people don't want to report to law enforcement or don't have trust in the system when we have numbers like this. However, again, some survivors do choose to go that route, and they, have the hope that their case will be different. And we will be there, every step of the way to support them in that process. Additionally, survivors of sexual violence or victims of crime there is a Crime Victims Bill of Rights. These are some of the rights that are available to them. So they should be treated with fairness and respect for their dignity and privacy, and to be free from harassment, intimidation, and abuse throughout the criminal justice process. That's like the main right that is granted through the Crime Victims Bill of Rights. It is important that people know that these only apply to victims once their case is in the criminal court system. So somebody who just made a police report or whose case has not been charged, unfortunately, these rights do not attach to them just yet. Crime Victims Compensation is another great program that the state of Illinois offers, which basically is a reimbursement program. So survivors of sexual violence who have had to pay for any expenses out of pocket, it could be relocation costs, it could be for accessing mental health care, it could be for getting accessing medical care or dental care, those kinds of expenses that may or may not be covered by their insurance or by a voucher. They're able to apply for reimbursement through the Crime Victims Compensation Program of the Attorney General's office. This is another victory. The total amount that they used to be able to reimburse was $27,000, and it changed recently to $45,000. And this is over the course of a survivor's lifetime. There are some rare occasions where Crime Victims Compensation will pay for any anticipated bills. That's a bit of a different process. So if any survivors are interested in being reimbursed for any expenses, connect with an advocate and we can help you through that process. Some of the important things to note in terms of, do I qualify for Crime Victims Compensation or not, or CVC? Cases of sexual assault, sexual abuse, human trafficking, survivors of those kinds of crimes are eligible for Crime Victims Compensation, but they must notify law enforcement within 7 days of the assault or the instance of violence. With a few exceptions, the applicant must file the application within 5 years of the date of the crime. It used to be 2 years, now it's 5. For minors, the date of the crime is when they initially reported that to a parent, teacher, or some other responsible party. They do have to cooperate with law enforcement to arrest and prosecute the offender. Again, vast majority of cases don't make it to a prosecution, but simply filing that police report and having communication with the detective meets the requirement of cooperation with law enforcement. And another way that they can meet the requirement is by obtaining a protective order, having an evidence collection kit done, or engaging in a proceeding involving the status of a human trafficking victim. Some of the expenses that are covered, I mentioned medical, hospital, dental expenses. Lost wages is another one. So a survivor who decides to take VESSA leave and not get paid during that time, they may be able to be reimbursed or make up those lost wages through CVC. They may also be able to obtain reimbursement for loss of tuition if they ended up having to drop out of school due to the sexual violence. Some of the expenses that are not covered are expenses that are not related to the crime, so they do have to be directly related or as a result of the sexual violence. They cannot cover pain and suffering, stolen, damaged, or lost property other than locks and windows, as well as attorney's fees.
Thank you, Carolina. So we are going to skip the next 2 sections, civil lawsuits and family law, just so that we can get to housing and finish up there. I just want to note that it is possible for sexual assault survivors to file civil lawsuits, both against the person who sexually abused them and potentially third parties who may be responsible. If you have any questions about civil lawsuits or family law, again, please reach out to either organization after the presentation. Housing, we're going to turn to Biz.
Hello, everyone. I'm Biz, and I'm here to talk to you about the Safe Homes Act. In Illinois, usually when you're signing a lease, it's about a year long. And so if something happens and you need to relocate quickly, there is a law that helps and allows you to do that. So the Safe Homes Act covers survivors of domestic violence, sexual assault, and stalking. And it also covers all of the private landlord-tenant leases, as well as subsidized leases, with the exception of the type of subsidies that live at the address and doesn't travel with the person. There's another complicated version of this for those addresses, and we won't be getting into that, but if that's you and you want to learn more about that, please reach out to us. So that's who can use this law, and on the next slide is how. Okay, so the way that you break your lease and qualify is you need to show your landlord that there is a credible imminent threat of future harm, that it will occur on the premises, and the way that you tell your landlord that is through a written notice. That's just a letter that you write to your landlord that explains those two things I mentioned before, and the timing of that letter is really important. It's either 3 days before you leave the apartment, or it can also be 3 days after. So you have a window of about 6 days to send that written notice to your landlord. But once you do send that written notice, it should protect you from a lawsuit that the landlord might file against you in the future. The important thing to note here is that if it is sexual violence that took place on the premises, you don't have to show that you're afraid it'll happen again, which is what the credible imminent threat is. That is, I'm afraid that that will happen again and in the future. But the pain and suffering of having to live in the same place where something happened to you, they said that that's enough. You don't have to show that this is a potential for repeat. So the way that the law works is that when you want to leave, you send that letter. And now that landlords know that this law protects them from being able to collect rent that occurs after you send that letter, it's supposed to be a deterrent on them filing a lawsuit to collect that rent in general. However, if they're not deterred and they file a lawsuit, this law says that you can show proof that you sent that letter, that you let them know that there was a credible imminent threat of future harm, and that you put them on notice that you were availing yourself of the Safe Homes Act. And that operates as an affirmative defense. So the landlord goes to court and say, you guys owe us this money. And you say, no, I don't. And here's the letter that shows that I knew that I didn't owe you any money, and I did everything that I needed to do to make sure that I didn't owe you any money. And then the lawsuit goes away. So this is the way that you protect yourself from a landlord trying to collect money for the rest of a lease when you are terminating your lease specifically for sexual violence or domestic violence. There are other remedies under the Safe Homes Act about if you want to stay in the apartment to make it a little bit safer. And if you want to learn more about those, you can reach out to us and we will tell you all about them.
We don't have time for questions, but I am going to leave this on the screen for the next 2 minutes with information about how to contact Legal Aid Chicago or Resilience if you need help with any of the things we talked about. Thank you so much to everybody who attended today, and thank you to my fellow presenters.
Thank you everyone for joining us. Take care.